Hello and welcome to today's program, Recharacterization of Royalty Purchases and Related Bankruptcy Risks. My name is Allison Schmidt. I'm the Director of the Life Sciences Law and Policy Center at the Berkeley School for Law and Technology. It's my pleasure to welcome you to this program, which is both part of a three-part series that we'll talk more about in a moment, and part of the BCLT Advanced Life Sciences Institute series. We thank the Berkeley Center for Law and Technology and the Life Sciences Law and Policy Center for their support of this program. So it's my pleasure to introduce you to today's expert panelists, Jeffrey Krause and Michael Farag, who are both experts in this space and lawyers at Gibson Dunn. So Jeffrey's a partner in the LA office of Gibson Dunn. He's a member of the firm's business restructuring and reorganization practice group. His practice is quite broad. It handles both significant debtor and creditor representations, acquirers of assets from Chapter 11 debtors, lessors, landlords, secured and unsecured creditors. Jeff's practice also involves advising boards and shareholders on fulfilling their fiduciary duties and minimizing litigation risks when faced with financial distress. So Michael Farag is an associate in the LA office of Gibson Dunn and also a member of the firm's business restructuring and reorganization practice group. His practice is focused on complex restructuring and insolvency proceedings, including Chapter 11 and out-of-court debt restructuring. So he's received awards for his work, including recognition in the 2025 issue of the Best Lawyers in America's One to Watch for work in bankruptcy, creditor debt rights, insolvency, reorganization, and bankruptcy litigation. That's quite a list. Very impressive. So with that, if we can hop to the next slide real quick. As I mentioned at the top, this is part of a three-part series exploring royalty finance. So we hope that you've been able to catch the first two recordings in the series. If you haven't, you're actually able to access these programs through our BCLE platform. That's at bcle.berkeley.edu. The programs in the series have been fantastic, so I really encourage you, if you weren't able to catch one or both of the earlier programs, to go back and catch those as well. So with that, I'm going to turn things over to our speakers.
Thank you, Allison. This is Jeff. We're going to start today with why we're talking to you about recharacterization, which almost always comes up in the context of bankruptcy proceedings. But it is important to focus on the issues at the outset of the case, because as you'll see as we go through these, at the outset of the transaction, as we go through these, that structuring the transaction carefully may minimize your risks in a subsequent insolvency proceeding. Michael, you want to kick us forward to the next slide? So today we're going to cover what does it mean to recharacterize a transaction in a bankruptcy context, what facts the bankruptcy court will look at to consider in deciding whether to recharacterize a transaction, and how does recharacterizing a transaction alter the buyer or secured lender's rights against the debtor to receive payment if it turns out the debtor is insolvent. All of those things are interrelated, so we may bounce around a little bit, but the goal is to address those more or less in that order. Next slide, Michael. So bankruptcy courts tend to look at the economic realities of a transaction, not what the parties call a transaction. We call it elevating substance over form because the words that the parties use, while they may be a factor courts consider, do not control. And the potential characterizations we're going to go through today that a court might adopt, which have massively different impacts in a bankruptcy case. The court could conclude that a transaction is a completed sale of an existing asset. There are some instances where the sale includes future after acquired property that doesn't exist yet. And it is possible in that context, the court will conclude that you don't have a consummated sale, but you do have a contractual commitment to make a sale in the future, which has different rights in a bankruptcy. Or if the court concludes that the transaction really doesn't look like a sale, it hasn't transferred the actual economic ups and downs of the asset purportedly being acquired, and if the seller is required to pay back the purchase price no matter what the product acquired does, then it's more likely to be treated as a loan. Whether it is a loan or an unsecured loan depends on how it is documented, and we'll go through those details a little bit later. And in the worst of all possible treatments in connection with the bankruptcy case, it's possible that the court could recharacterize the transaction as an equity investment in the seller of the asset if the terms are not limited to the individual asset being acquired. If the transferee does not receive the actual economic consequences of what happens with the underlying asset, if I'm buying an account receivable, I should get the proceeds of the account receivable, but nothing more than the proceeds of the account receivable. If the seller is obligated to repay me, even if the account receivable doesn't get paid, then I haven't taken the downside of the asset. And if I don't get 100% of the receivable, I haven't taken the upside. And in either or both of those circumstances, it looks like I haven't really bought the asset, as opposed to providing money to the seller, which eventually the seller has to pay me back. And that's when things may be recharacterized as a loan. Michael, you want to take the next one?
Yeah, so one of the basic principles of bankruptcy is that when a bankruptcy case is initiated, there's this fiction where a bankruptcy estate is created. And that is how the court determines what belongs to the estate and will be administered, what property rights are not part of the estate. And that is all laid out in Section 541 of the Bankruptcy Code. So the property of the estate is measured in the first instance as of the filing of the bankruptcy petition. And it includes all of the property interests the debtor owns. So that's all legal and equitable interests of the debtor in property as of that date. So what does that mean for our discussion today? Well, first, if the debtor has completed a transfer of property prior to the bankruptcy filing, and that transfer has been consummated, then that asset is not property of the estate. It is property of the purchaser or the transferee. If the asset doesn't exist as of the bankruptcy filing, or the debtor doesn't yet own an interest in that asset, the asset may become property of the estate subsequently based on post-petition property interest. If the right to receive cash in the future is transferred, but the cash remains with the debtor or is commingled with the debtor's property, there's a real risk that the court would conclude that that commingled cash is actually property of the bankruptcy estate, which means if you as a transferee think that you're getting rights to cash, but you don't actually get the cash and the debtor commingles that cash with its own assets, then after a bankruptcy filing, you run the risk of, in fact, not having a property interest in that cash or losing it to the bankruptcy estate.
So the bankruptcy courts, in trying to figure out what is the right way to treat parties, look at the economic substance of the transaction the parties have engaged in. Early on, there were a few bankruptcy cases that adopted a federal common law standard of when is an asset been sold or when does the debtor still retain ownership of the asset. But the far larger body of case law and all of the more recent cases say that that is not a federal bankruptcy law issue, it's a state law issue. So that what rights a debtor has when it files bankruptcy are controlled by state law and can vary from state to state depending on what factors the state courts have looked at in deciding whether something is a true sale or a loan. So the case law may vary from state to state, even though the bankruptcy courts are applying the bankruptcy code to property ownership interests. Bankruptcy incorporates by reference state law on what those ownership interests are. We're going to go through a lot of factors that courts look at in deciding whether or not to recharacterize a transaction or to accept at face value that the buyer has in fact purchased the asset. There is no one prescribed formula. There is no one factor that is all controlling. Courts are really trying to drill down on what are the economic realities of the transaction. Michael, you want to go to 8?
Now, as Jeff pointed out early on, bankruptcy courts will look at the economic realities of a transaction and not rely on the form. And for that reason, an analysis of characterization or recharacterization of a transaction will include a number of factors, and we've included here some examples of how different courts have applied different factors, and we'll run through those in a minute. But the important takeaway, as Jeff said, no single factor or combination is dispositive, and the court will look at all the facts and circumstances. So highlighting what we view as the more important factors that courts look at. So the stated intention of the parties is obviously important, but if the parties call a transaction that's clearly a financing, if they call that a sale, the court won't give as much weight to what they're calling it and how they're characterizing it. But it is an important factor in the analysis. There's an overarching theme that you'll see in a lot of these factors, which is who really retains the benefits and burdens associated with the assets, who has control over the assets and how they're disposed of. So this next factor is really whether the transferor has retained the economic benefits and burdens of the asset. So as an example, if the transferor has an option or a right to reacquire the subject assets or retain any surplus or excess collections, that doesn't really look like what we think of as a traditional sale. Risk may also shift if the transferee has the right to put the transferred assets back to the transferor. Courts will also look at whether the economic risk of loss has been transferred or whether the transferor retains that risk. And often that's done through providing a guarantee or whether the transferee has recourse against a transferor or a third party. Whether the transferor is entitled to make decisions regarding the asset. And that goes to the issue of control. Decisions that don't require the consent of the transferee tend to take us away from the land of a sale.
And on that point of control, it is very common in the royalty area for the seller to service the collection of the royalties from the third party. And courts will look at, does the transferor have the right to make unilateral substantive decisions about what to do with the asset that they are servicing? Or does the buyer get to instruct the seller, which makes it look more like the buyer's actually required the economic risk? So when we talk about control, a servicing agreement in and of itself is not a bad fact if the buyer is agreeing to service the collection of receipts that it is sold. And as we get into some of these transactions where there's a sale of only a percentage interest, that's going to be the norm, as long as the buyer has a say in what's done with respect to the asset itself. So, Michael, why don't we go to the next slide? Whether the rights of the transferee mirror just the pass-through of the asset is important. There are transactions in which a party gives money to the seller and is entitled to be paid back that money with, for example, a floating interest rate, but that the underlying asset that's being acquired has a fixed rate of return. Courts will say that doesn't look like a purchase because it looks like the party parting with the money looks more like a lender who's getting a floating interest rate than like a buyer who is getting just the benefit of the asset being acquired. Going back to the question of how do the parties, what do they call the transaction? How do they treat the transaction? Courts will look at how the transferor and transferee account for the transaction on their financial statements and on their tax return filings. It's interesting. There was a day when I thought the tax accounting for a sale and leaseback transaction, which is similar to the recharacterization risk in connection with royalties, that if a debtor in a bankruptcy proceeding had reported it as a sale on their tax returns, that would be conclusive. Or on the flip side, if they didn't report it as a sale, but treated it as a loan and as the payments being made as deductible interest, that would be determinative. But there are bankruptcy cases that basically say, no, that's just tax, and tax is different, and we don't have to follow the tax treatment of the transaction. So courts will look at it as an indication of what was the party's intent, but tax treatment doesn't necessarily preclude or govern the treatment of the underlying transaction. Whether the transferor commingles the subject assets with its own assets, that really goes to two different substantive economic considerations, one of which is the owner of cash usually has control of its own cash. And if the buyer is allowing the seller to collect and commingle the cash with its own cash, that doesn't look like the buyer has obtained control. It's also important as a practical matter if the seller winds up in a bankruptcy proceeding, because unless the cash can be specifically traced to the royalties that are being paid in, the court is likely to say cash in a debtor's bank account is property of the bankruptcy estate and doesn't have to be turned over to the buyer, even if the court ultimately concludes the transaction should be treated as a sale. It may be a sale of future revenues that come in, but if money has come in and been commingled, the court is likely to allow the debtor to keep that cash. Another factor courts look at is whether before the sale ever closes, the buyer goes out and makes an independent evaluation of the assets, looks at, is the party paying the royalties good for the money, examines their contract, examines their payment history, their future payments, their projected future payments. And that kind of information shows that the buyer really thinks they're acquiring the asset. If they're lending money to the seller and the seller is going to pay them back no matter what happens with the royalty stream, they care less about the underlying credit rating or revenue stream from the ultimate licensee. And then the last factor on this slide is what notice is given to the third party. So if a licensee is paying royalties to the seller, is that licensee told by the seller, we've sold the right to receive the payments from you? Next slide, Michael. So we want to go through a few hypotheticals really just to show you that there are hybrid transactions that seem to have or do have some of the characteristics of a loan and some of the characteristics of a sale. And it can become sort of a slippery slope that you've concluded one transaction should be treated as a sale, and then the next transaction is just a little bit different, but a number of little differences can make all the difference in terms of how a bankruptcy court treats the transaction. So the first hypothetical is sort of the prototypical sale of an asset. The transferor transfers all of its rights in a particular drug that it is licensed for 20 years. It transfers the IP, it transfers the right to market the drug. It takes an assignment of the agreement with Big Pharma, the licensee, and it pays $100 million. It's entitled to receive whatever Big Pharma pays in the future, no more, no less. That is clearly should be treated as a sale. If you have the same transaction and the transferor agrees to service the collection of payments from Big Pharma, so it has control over the money when the money first comes in, and it gets paid a fee, that is still a sale, although it may get closer to the line if the transferor has complete discretion on collection efforts from the licensee, because that makes it look more like they have an ownership stake. But if the transferee is receiving 100% of the ups or downs in the royalty stream, that should still be treated as a sale, we think. The third hypo is the same as the first, except that instead of buying 100% of the income stream from Big Pharma, the buyer is only acquiring 5% of that stream, not an uncommon transaction in the royalty world. The reason this makes the analysis for recharacterization purposes more complicated is because the underlying drug and IP are not conveyed. It's just a conveyance of the income stream. And we'll talk a little bit in some of the later slides about whether you can convey income that hasn't come in yet in the context of a bankruptcy proceeding. But if this transaction is documented carefully and the buyer transferee does in fact receive 5% of the royalties paid, whether that is a lot more than they paid for the purchase price or a lot less, it probably still would be treated in a bankruptcy proceeding as a true sale of that 5% interest. We'll get into some complications of how a bankruptcy court would deal with the 95-5 split when income comes in the future. The hypo 4 is the transferor owns the drug, but doesn't have any contract with any party to generate future sales. It's going to go out and market the drug, and the transferee buys a 5% of all future sales under all future contracts. Now, our finance counsel went through this and described it as a synthetic royalty, synthetic in the sense that there's actually no license agreement with an existing royalty to be conveyed. This should be permissible as a sale, subject to a very important litigation risk we're going to talk about in some of the later slides, of whether or not what is being sold actually exists. Because if it does not exist, then this isn't a sale, it's a contract to sell when the royalty stream exists in the future. And as Michael will show in a little bit, a contract to sell is a different animal in a bankruptcy and might be subject to rejection and less than full treatment in a bankruptcy. The next typo is the same as one, going back up to the basic sale, except that the transferor agrees to reconvey title, that should say to the transferee, for $1 once it has received a $200 million return. So in this context, the transferor gets 100% of the upside of the asset until it gets double its original investment, but then it gets none of the upside, and all of the upside stays with the transferor. This one I think courts would struggle with, because the entire economic value has not been conveyed to the transferee. And hypothetical 6 is sort of the reverse. The transferor agrees that if the transferee has not received $200 million, and I'm going to back up. The transferor here is transfer of the asset, not of the cash that's being received. So if the recipient of the cash agrees that even if the recipient of the royalties doesn't receive $200 million, the transferor will pay the transferee whatever amount of money is necessary to get the total return to $200 million. Here, the recipient of the cash is committing to repay the cash no matter what the asset does in its performance. And that looks more like a loan, and a court might recharacterize that transaction. Michael, you want to go to the next slide?
Yeah, so let's talk about the consequence of whether the transaction is a loan or a sale. So if the transaction is recharacterized as a loan, whether it's secured or unsecured, the quote unquote lender's rights can be modified under a Chapter 11 plan. That's in contrast to a consummated true sale prior to the bankruptcy case of the asset. If there is a true sale, then by definition, the property interest was conveyed to the buyer, and that property is not property of the bankruptcy estate as of the petition date. So therefore, that buyer's rights can't be modified under a Chapter 11 plan, and it can continue to collect on its income stream. So as Jeff mentioned, there's a complication where the transferor has agreed to sell an asset in the future, so that asset may not exist yet. That agreement would be characterized as a contract, likely an executory contract, which, as I'll touch on in a few minutes, is subject to certain treatment under the bankruptcy code, which is favorable to the debtor and can prejudice the rights of the counterparty. If the asset being transferred doesn't exist yet, the debtor transferor probably can't convey that asset. And really all you have is a commitment. It's a promise to convey the asset when it does come into existence. So what happens when there's a right to receive income from future sales of drug A if the owner of drug A doesn't yet have any agreements or licenses in place with a customer? That's probably going to be along the lines of what we touched on earlier, more of a contract right that doesn't give the transferee the benefit of what it had bargained for prior to the bankruptcy case.
So if a loan or if a transaction is recharacterized as a loan, some of the consequences of the debtor filing a bankruptcy proceeding, the deemed borrower under the recharacterization, are that the automatic stay under Bankruptcy Code Section 362 prohibits any actions by the creditor to enforce its lien on the assets, to insist on receiving the cash, or to foreclose on its collateral. The bankruptcy court will grant relief from that stay and allow the secured creditor to exercise remedies if the debtor does not have any equity in the collateral, so the future income stream is worth less than the deemed loan from the lender, and the collateral is not necessary for the debtor's reorganization, or if the secured creditor is at risk of the value of its collateral declining over time. Under Section 363 of the Bankruptcy Code, the debtor can use any assets that are property of the bankruptcy estate, even if those assets are subject to a deemed loan. So if money comes in from the licensee of the drug, the debtor can spend that money to continue its operations as long as it can show that the debtor, the deemed secured lender is not having the value of its aggregate collateral go down over time. So it's critically important if it is a deemed loan, then the debtor still owns it. If the debtor still owns it, then the debtor can use it, and the secured lender cannot insist on enforcing its rights, and that disappoints the expectations of the party who thought they acquired the asset. And it is one of the reasons why people try to create true sales to avoid property becoming part of the bankruptcy estate. Next slide, Michael.
So the transaction is recharacterized as a secured loan. The question becomes, how do you value the amount of the claim of the lender here? under Bankruptcy Code Section 506, the amount of a secured lender's claim is limited to the value of the collateral securing its claim. So we've provided a couple examples here. So if the lender is owed $75 million and the collateral securing that claim is $100 million, valued at $100 million, the secured claim is $75 million, which is what the lender is owed. Plus, if the lender is entitled to interest and fees under the agreement, so long as the value of the collateral exceeds the value of that claim amount, the lender is entitled to interest and fees after the bankruptcy filing. And you'll see we noted in the third bullet, that doesn't mean it doesn't equate to an immediate cash payment of these amounts. Rather, think of it as an increase in the claim to which the lender will be entitled under any Chapter 11 plan. That's in contrast to the second bullet. Same scenario in which the lender has a claim of $75 million, but now the value of the collateral is only $50 million. The secured claim is capped at the value of the collateral, $50 million. The lender is not entitled to accrue interest and fees after the bankruptcy filing. And the creditor is left with a deficiency claim, a $25 million unsecured claim, which in most bankruptcies is not very valuable because that deficiency claim will be at a lower priority under the bankruptcy code with other general unsecured claims. And those claims often get cents on the dollars. So as I noted earlier, if a secured creditor is entitled to accrue interest and fees post-petition, that's really just an increase on the claim amount and not a cash payment in the ordinary course.
So if the purchase is recharacterized as a secured loan, one of the challenging questions is, does it include royalties that first become payable after the bankruptcy petition is filed? And that turns on whether those exist as of the petition date or in the alternative, exist in concept. I'll get into in a second of what constitutes an account under the Uniform Commercial Code. And also whether the deemed lender has a backup security interest in the underlying IP and license agreement if there is a license agreement. And remember, in a synthetic royalty, there is no license agreement, but there is the IP. Under state law, a contractual commitment by a borrower to grant a security interest in after acquired property is completely valid under Article 9 of the UCC. And whenever the debtor acquires an interest in the collateral, which is necessary for a security interest to attach under Article 9, the debtor has to have an interest in the collateral. So when the debtor has an interest, the security interest automatically springs into effect. The bankruptcy code changes that rule and has two separate rules in Bankruptcy Code Section 552, which are really designed to allow the secured creditor to keep its lien in after acquired property if that after acquired property is proceeds, products, offspring, or profits of their collateral as it existed on the petition date. But if it's not, if it is just a newly generated account receivable from post-petition actions by the company, the lender's after acquired security interest will not attach to those assets. So in the context of synthetic royalties, where there may not be a contract with a licensee that can be the source of the pre-existing asset that could be pledged and could generate proceeds, a transferee should take a security interest in the underlying IP, the patents, the know-how, the drug name, trademarks, whatever it is, because then when there are future royalties generated by the use of those assets, the transferee can fit within the concept that those future royalties are products or profits of their existing pre-petition collateral, and their lien would attach. What the lien will or won't attach to will go back to the question on the last slide. Michael was talking about values. Well, value is not written in concrete, and it's not something that we all just know that the value of this is X. A bankruptcy judge has to decide what the value is, and in deciding what the value of the collateral is, has to decide what the collateral is, and does it include after acquired accounts receivable generated in the first instance post petition. So one of the concepts under the Uniform Commercial Code that is helpful in the context of synthetic royalties is the question of when does an account arise? And the term account is very broadly defined in Article 9. And an account, it is important to recognize, is not the same thing as an account receivable. An account receivable is an obligation of somebody to pay the borrower for either goods or services that were provided. An account in Section 9102 of the UCC means any right to payment of a monetary obligation, whether or not earned by performance, for property that has been or is to be sold. Now, if you read that literally, that means an account exists before a license for the IP exists. An account exists before the particular drugs have been sold and an account receivable arises. I've actually said to a court, not in the context of royalties, but in the question of what is an account for things like franchise agreements or leases of real property, that an account exists as soon as you own the underlying asset. So if I own a table, I actually have two assets. I have the table and I have the account, which will arise when I sell the table. I can pledge either one of those. And so in our synthetic royalty context, we take a security interest in all accounts of the borrower if it becomes a deemed loan. We take a backup security interest in IP and trademarks and the underlying assets which will generate future royalties. We specifically say this isn't a loan. We don't intend it to be a loan. We intend to be making an absolute purchase of the assets. But in the event this is recharacterized as a loan, then it is secured by, and the laundry list of things I talked about. If the debtor can confirm a plan of reorganization, and the vast majority of Chapter 11 debtors do not confirm plans, so it's not a foregone conclusion that a plan will be confirmed if a debtor files. But if a debtor can confirm a plan, it can change the interest rate and the repayment terms so long as the value of the secured creditor's interest in collateral is being preserved. So going back to the two hypotheticals where there's $75 million of debt and either $100 million of collateral or $50 million of collateral, in the $100 million of collateral value, the plan has to preserve the creditor's right to get paid their full $75 million plus interest. In the $50 million of collateral hypothetical, the creditor has to receive $50 million over time with interest. Now, the plan gets to change the interest rate. So in many royalty transactions, especially synthetic royalty transactions, which tend to be marginally riskier because there's not yet a license with a specific pharma company to look to as the likely source of repayment, the rate of return is significantly higher than the rate of return a bankruptcy court is likely to impose under a Chapter 11 plan. The Supreme Court has said that the bankruptcy court should start with a risk-free rate of interest like prime, and then add to that anywhere from 1% to 3% on account of the specific risks of the type of business that is being reorganized. So that return is likely to be much, much lower than what the contract actually provided for. The court can extend the repayment term, often for several years. The debtor has to prove the plan is feasible. That means that they're going to be able to make the payments that they commit to make in the plan. And the creditor does get to retain its lien on the collateral. So if the debtor defaults, the creditor should be allowed to foreclose on the collateral and take ownership of the assets it thought it had ownership of in the underlying assets. If the value of the collateral is less than the debt, again, recognizing that what the value is may depend on whether the collateral exists yet, since if it does not exist yet, the lien on after acquired property may be cut off. The secured claim doesn't have to be paid in full if the value is less than the debt. Michael, I think it's next slide, yours or mine?
I think that is you again.
Okay. So the takeaway is that the amount that can be paid under a plan is a lot less than the debt, and the payments can be stretched out over an extended period of time, even if the loan is secure. But the question of when is the loan not secured can create even greater risks. And a loan that is recharacterized as a purchase that is recharacterized as a loan is only secured if the secured creditor has recorded a UCC financing statement saying, I have an interest in the future royalty stream, the IP, the various assets that the buyer should take a backup security interest in. Because in bankruptcy, only perfected security interests are honored as being valid secured claims. So if I have an unperfected interest, I didn't record a UCC1. I thought I had outright ownership, so I didn't bother to put the world on notice by recording a financing statement. My debt will actually be an unsecured debt. And if it's an unsecured debt, the rules are even worse than what we just talked about for secured creditors. An unsecured creditor accrues no interest during the window between when a petition is filed and when a plan goes effective. And that's usually a few months to a year, but no interest, no fees during that time period. And after confirmation of a plan, the unsecured creditor can start accruing interest at probably the same kind of a rate as the secured creditor, but they're only entitled to be paid some amount more than the liquidation value of the company if the creditors as a whole accept the plan, and the acceptance by unsecured creditors is 50% in number and 2/3 in dollar amount of the creditors who actually vote. So if there are a lot of other creditors and the deemed buyer, the deemed lender who thought they were a buyer doesn't have more than 1/3 of the debt, they can't block creditors from accepting a plan. And if creditors accept the plan, the value available can be whatever the body of creditors has accepted, and probably a lot less than what is owing. As Michael said earlier, if you have that unsecured deficiency claim, it likely doesn't get very much. That's true of your whole claim if you haven't perfected through recording a UCC1. And if the debtor sells its assets in a bankruptcy proceeding, the proceeds of the sale would be available to unsecured creditors before equity can keep anything, but it's not clear what those proceeds will be, or that they would be sufficient to pay unsecured creditors in full. And if you are deemed to be an unsecured creditor, then you share the haircut that all of the other unsecured creditors would take. Michael, you want to pick up?
Yeah, so we mentioned earlier another potential outcome is that the transaction is viewed not as a sale and not as a loan, but as an executory contract subject to treatment under Section 365 of the Bankruptcy Code. Courts generally apply the same test to determine whether a contract is an executory contract, which is, do both parties to the contract have outstanding material obligations as of the date of the bankruptcy filing that are so material that if unperformed, they'd constitute material breach, excusing the other party from performance. If that's the case, the debtor can do what it wants under Section 365, including relevant here. They can reject those contracts. And if a debtor rejects the contract, you as the contract counterparty are left with a claim for breach of contract damages that you can assert and get treatment under the Chapter 11 plan along with similarly situated creditors. So assuming you have a general unsecured claim for breach of contract damages, it'll fall into the class with other general unsecured claims, which, as we've noted a couple times, likely will not receive much value on their claims. The only way that claim would be a secured claim for breach of contract damages is if the contract provides for that and if the secured party has perfected its security interest. But in most cases, it's unsecured. So taking the scenario in which a transferor agrees to convey the asset to the transferee under, call it a purchase and sale agreement, and the bankruptcy case is filed prior to the transfer of the assets, the debtor can likely reject that contract because the assets haven't been transferred yet. So there are material obligations outstanding, and the debtor is excused from performance. The contract counterparty is left with a claim, a breach of contract damages claim. If an account for UCC purposes exists and is conveyed before the bankruptcy filing, then the transferee already owns it, and it is not property of the bankruptcy estate. It can't be impacted by the filing. If no account exists when the bankruptcy case is filed, then we are back in the territory of an executory contract. You're likely left with an agreement to convey the account when it does come into existence, and rejection of the contract results in a breach of contract damages claim.
And I would just note there, buyers of synthetic royalties take the position that an account does exist and the purchase is a consummated sale transaction. The challenge is there is little to no case law on when does an account come into existence. And so if it doesn't, then you have this executory contract problem unless the transferee has also taken a backup security interest in all of the underlying assets. You want to go to the next slide, Michael? So if a transaction that a buyer thought was a purchase gets recharacterized as a loan, then it is subject to the typical usury rules for any sort of a loan. So a court would have to determine what is the return that the buyer is getting. They paid a purchase price that's deemed to be a loan. If you look at everything they're entitled to in terms of revenues out of the asset, that's the return. What would the deemed interest rate be? And because many of these royalty transactions, especially synthetic royalty transactions, which are marginally riskier, have significant recoveries where it's measured in double or triple the original investment over a period of years, there is a real risk that the loan could be usurious. Whether it's usurious or not is controlled by state law. There's not a separate bankruptcy standard for that. And the question is, what law governs the transaction? And that law probably controls whether the loan is or is not usurious.
And one other point we wanted to highlight is just being mindful when negotiating liquidated damages provisions in events of default. So that's not to say don't be aggressive in negotiating for the best outcome in the case of default or events of default or breaches, but just be mindful that in a bankruptcy case, the debtor or an unsecured creditors committee may seek to claw that back as unenforceable. So our recent example here is from the Chapter 11 case of Clovis Oncology in Delaware. There was a clinical funding arrangement where the lender provided $150 million in exchange for a percentage of net sales of a drug until that lender received a total of $350 million, so more than double the amount of funding provided. The agreement provided that in case of an event of default, which included bankruptcy, the full $350 million amount would be due. The creditors committee initiated the process of seeking to characterize that accelerated payment term not as liquidated damages, but as a penalty that was unenforceable under state law. Before the court was asked to address the issue on the merits, the parties settled, so we don't have a definitive answer whether or not this would have been an issue, but just know that it may come up, and take that into consideration when drafting these provisions.
I want to thank both of our speakers for a really excellent presentation. I learned a lot. I hope you did too. I guess I'm putting the speakers on the spot a little bit. If you have questions after this presentation, I believe the speakers would be open to you reaching out, either through LinkedIn or over email.
We would be delighted to speak to people who have questions.
Wonderful. Thank you so much for joining us for this three-part series. We really appreciate the attendance and the engagement. We're really thankful to Gibson Dunn for sharing their expertise throughout these sessions as well. Have a great rest of your day.